If you're renting in New South Wales and you have a dispute with your landlord that's difficult to resolve, one of your options is to go to NCAT, the New South Wales Civil and Administrative Tribunal. NCAT helps resolve rental disputes fairly and legally. It might seem daunting at first, but once you understand the process, it's much more straightforward than you think. This video will walk you through what the tribunal does and how to prepare. Either you or your landlord can apply to NCAT. The tribunal's role is to hear both sides of the dispute and make a decision based on the law. NCAT is less formal than a court, and in most cases, the tribunal prefers that you represent yourself. To help prepare, you can get advice beforehand from your local tenants' advice and advocacy service. If you need to apply to the tribunal, you'll be the applicant. You can submit your application online at the NCAT website or download and fill out a paper form. It's important to clearly state the orders you'd like from NCAT and the reasons why. You should refer to the Residential Tenancies Act 2010, which is the law that protects renters in New South Wales. NCAT has a fact sheet listing common tenancy issues and the relevant law sections, or you can ask your local tenants' advice and advocacy service for help. If you need an interpreter or have special needs, NCAT provides free language support and additional services for people experiencing hardship, including domestic violence support. Once you've applied, you need to gather evidence to support your case. This might include emails or messages between you and your landlord or real estate agent about the issue, photos or videos of the property like repairs needed or damages, tenancy agreements and condition reports, copies of notices or letters related to the dispute, or rent receipts or bank statements showing payments made. You need to provide evidence to NCAT so they can make a decision. The tribunal will tell you how and when to do this, but it's usually a good idea to make 3 copies, one for NCAT, one for the landlord, and one for yourself. This makes it easier to refer to your evidence at the hearing. If the landlord applies to the tribunal, that makes you the respondent. You'll receive a notice of hearing, which will tell you when and where your hearing will take place. If you get a notice of hearing, don't ignore it. If you don't attend the hearing, NCAT can make a decision without you, which may be worse for you, as they haven't heard your side of the story. So make sure you turn up and have your say. If you're an Aboriginal or Torres Strait Islander tenant, you can ask to have your case heard on the Aboriginal tenancy list. Support services and specialist Aboriginal tenant advocates are available. A tribunal conciliator can help you reach your own solution. Tribunal members can take more time with cases on the Aboriginal list if you can't reach an agreement. To get the best outcome, be prepared. Follow these 5 steps. 1. Make a timeline. Write down everything that's happened in order with dates to clearly explain your case. 2. Gather and organise your evidence. Numbering pages and creating an index makes your documents easier to navigate during the hearing. 3. Review the landlord's evidence. Read their documents carefully so you can respond effectively. 4. Plan what to say. Keep it clear, respectful, and to the point. Think about any questions you might need to answer ahead of time. 5. Plan your hearing day. Check if your hearing is online, by phone, or in person, and make arrangements to attend on time. If your hearing is in person, arrive early and bring your bundle of evidence. If it's by phone or video, find a quiet place and test your internet or phone connection beforehand. At the start of the hearing, you'll meet the NCAT member, the person who listens to both sides and makes a decision. The member will send you and the landlord out for what's called a conciliation. It's basically a chance for you to talk through the case and try to resolve the matter outside of the hearing. This is often a time renters can negotiate with the landlord to reach an agreement. If you're unsure about negotiation, check out our tips for negotiating with the landlord at tenants.org.au. If you and the landlord can't reach an agreement in conciliation, your case will go to a hearing. The conciliation and hearing usually won't be on the same day. At the hearing, the applicant, the person who lodged the claim, speaks first, Then the respondent, the other party, responds. The NCAT member may ask you both questions. Remember to speak clearly and respectfully. Stick to the facts. The tribunal is interested in evidence, not opinions, and address the member as member. After hearing both sides, the NCAT member will make a decision. This is called an order. You'll receive a written copy of the order either on the day or within a few weeks. Everyone must follow tribunal orders. If the landlord doesn't comply, you may be able to take further action. If you believe the decision was legally incorrect, you may have the right to appeal, but you'll need legal advice and appeals must be lodged within strict time limits. Going to the tribunal might feel overwhelming, but it's designed to be accessible for renters. The law protects your rights and you have the opportunity to present your case. For more information, visit tenants.org.au or the NCAT website. You're not alone. There are tenants' advice and advocacy services available to help you through the process. Good luck, and remember, help is there if you need it.